Hi, so welcome to session number 46, in which we're going to deal undervalued transactions as explained before. There are four types of avoidance transactions. Today, we are going to discuss the second type of avoidance transaction, which is undervalued transaction. But before that, a quick recap of the previous session where we talked about preferential transactions. Section 43 speaks about preferential transactions. It makes a reference to an antecedent transaction basing on which a preferential transaction is entered, and there we talk about when is that presumed to be a preferential transaction, and the burden of proof lies on the other party which has entered into a preferential transaction. This is what we have done under section 43. After that, we have seen under section 44 that the adjudicatory authority on application made by either liquidator or resolution professional will pass an order, and there are 7 or 8 types of different orders it can pass. After that, we have seen with the help of a case law as to how these preferential transactions are analyzed, understood and treated under IBC at the time of liquidation or CIRP. This is a recap. Let's quickly move to current session in which we're going to talk about undervalued transactions. Section 45 of the IBC talks about undervalued transactions. Please remember the sequence. 43 is preferential transaction, 44 is orders, 45 is undervalued transactions, and accordingly it covers transactions entered into during the relevant period that are considered undervalued. So, what are the types of undervalued transactions? Number one, if during a certain period before the commencement of the CIRP, if there are certain transactions entered by the CDE which are given in the green and orange boxes, then such transaction can be called as an undervalued transaction, and this can be treated as an avoidable transaction, right? So what are the two types of undervalued transactions done during the relevant period? Number one, if the corporate debtor has given any gift to any person. Remember, a very interesting point actually. Why are companies floated by any person? Companies are floated with the objective of making profits, and those profits are distributed to the shareholders who invested money. Now the question is, can a corporate debtor, like a individual member, actually gift things or properties to any third party? The moment you're gifting, it is understood that there is some kind of a inherent malified intention which is obvious, So, if there is a gift during the relevant period before the commencement of the CIRP or liquidation, then such transaction can be a undervalued transaction, and how to deal with that we will see eventually. Part 2. If the company has transferred an asset for a consideration that is significantly lower than what is paid by the corporate debtor for that asset, then such transaction can be called as an undervalued transaction. Let's simply understand what I mean. Let's say I bought a land for maybe 5 crores in 2005 in a certain place. After 15 years, maybe in 2021-22, when the CIRP was about to begin, I transferred this land at a price of 1 crore to some party. This is an unbelievable undervalued transaction. Why? If you bought a property in 2004 or 5 at 5 crores, that today should naturally be valued at 30 to 40 crores. That's how the real estate has boomed in India. But now if you really value that at 1 crore and sell it to some party, this is an undervalued transaction. But please understand, it depends on type of asset. If I have bought a car in 2005, let's say a Rolls-Royce car in 2005, a certain model would have costed me 5 crores. At the end of 20 years, in 2023-24, at what value can I sell this car? Obviously, you will sell this car at a phenomenally lower value of something like 50-60 lakhs. That is not an undervalued transaction because the asset is actually depreciated. Remember that. We are talking about those assets whose value either appreciates or at least remains intact. But those assets which are depreciating, their market value is phenomenally lower. In that case, we don't call them as undervalued transaction. This is purely common sense. So let's move forward. And such transaction, if it is not in the ordinary course of business, whether the gift or the sale of asset is not in the ordinary course of business, then such transaction might in all probability fall in undervalued transactions and hence can be avoidable. What is the relevant period when this transaction can be considered as undervalued? Let's understand this. I have done a transaction about 10 years ago at a lower value. CIRP is commencing 10 years later. This transaction that is done 10 years ago will have no influence on CIRP today. Hence, such transactions cannot be avoidable. That's why the time frame before the commencement of the insolvency or the liquidation, what time the transaction took place. If it is within the relevant time which is mentioned in the section, then it's avoidable transaction. So let's see what is the time. If this transaction of the gift or transfer of property at a less value is to a related party, that means the relative would mean the relative of a director, relative of a promoter, employee of the company, or to holding company or subsidiary company. If you are doing this transaction, the time period is I can go back 2 years from the date of insolvency and still call it as an avoidable transaction. But if the same is not a related party transaction as given in the second part of the table, second row, then the time frame that I can go back is only 1 year, right? So for related party transaction, I can go back 2 years and check whether it is avoidance transaction. But for not a related party, I only have 1 year to go back and check whether it's an avoidance transaction. This is good for the corporate debtor. The more time frame you have, more transactions can unnecessarily create trouble. Therefore, we have taken a relevant period of only 2 years for a related party, 1 year for unrelated party. The adjudicating authority may require an independent expert to assess evidence relating to the value of the transactions. Most of the time, for a common man or for a jurist, even an adjudicatory authority's judicial member or a technical member, it might be very, very difficult to determine whether a transaction is undervalued or not. Example, if I have a patent right or if I have a registered patent in my name which is made in 2020 for a certain value, which I am going to sell now at a certain value, will that patent right be sold at a lesser value or more value is something that is impossible for me or for a judge to determine. Hence, this has to go to somebody who is an expert in valuation of intangible assets, and only that person can tell whether this is undervalued or overvalued. Hence, the section itself provides that in case of doubt, adjudicating authorities can take the view of an expert to understand whether the transaction is undervalued or not. If it is so, if I have decided for myself as a liquidator or a corporate or a resolution professional that the transaction is actually an undervalued transaction, what should I do? Or if the creditor has realized that there is an undervalued transaction which is not realized by the resolution professional or liquidator, these are the circumstances, right? In the first circumstance where liquidator RP has already seen that it is a undervalued transaction, he will make an application to NCLT. We know that, and NCLT will decide it as avoidable transaction. But if it skips the attention of a liquidator or a resolution professional, then maybe a creditor will himself realize that there is an undervalued transaction. Can he make an application to NCLT? Absolutely yes. Section 47 of the IBC provides that the creditor can make an application to NCLT. If an undervalued transaction has occurred and the liquidator or resolution professional has not reported it to the NCLT, a creditor member or partner of the corporate debtor can apply to the NCLT to have the transaction declared void and to reverse its effects. Now, apart from consequence of such transaction or setting aside the transaction, there is also one more important aspect that you should observe. If there was an avoidable transaction which is pointed out by creditor, what was the RP or liquidator doing? Why didn't they point out that there is a certain avoidance transaction that has occurred? Hence, if the adjudicatory authority feels that the resolution professional or liquidator is at fault and there should be a disciplinary action against them, then the NCLT will ask the board or the insolvency professional agency to look into actually disciplinary aspects of the liquidation professional. Let's read the paragraph. The NCLT has the authority to initiate disciplinary action against the resolution professional or liquidator if it is found that an undervalued transaction took place and the RP or liquidator failed to report such transaction to the adjudicatory authority. Then, whoever makes an application, whether it is applicant, whether the applicant is a resolution professional or the creditor, the effects of such application will be dealt in section 48 of the Act, where orders can be passed for undervalued transactions. So we are now trying to understand what kind of orders can be passed by adjudicating authority under section 48 where an avoidance transaction is reported to NCLT. Number 1, require the property which is dealt as an undervalued transaction and transferred to a third party will now be brought back into the possession of the CD. This is a primary order. That is, now the property will vest in the CD itself. 2, if there is any security interest in the properties of the CD created, then adjudicating authority can say that this particular security interest is discharged. Hence, there is no security interest anymore on the property of the corporate debtor. Then the third order, require any person to pay certain sums in respect of benefits received by such person. I told you an example where a 25 crore worth property is transferred to a person at 5 crores. That's a undervalued transaction. NCLT may now ask that person to give back the 20 crores which he enjoyed as a benefit because of the undervalued transaction. Then the last one is require payment of such consideration by any party which it had not paid. So we have seen 3 sections, 46, 47 and 48. In 46 we have seen that the resolution professional or liquidator will make an application in case there is an undervalued transaction. 47, the application will be made by the creditor, and 48, what kind of orders can be passed by NCLT or adjudicating authority. So what kind of transactions can be undervalued transactions? We are looking at the example. Mr. Preetham Tadani is the founder and director of Tadani Cements Limited. The company borrowed a loan of 1,500 crores from no bank limited and is on the verge of default. Realizing the potential threat of insolvency and consequential CIRP, the company sold one of its plants with a huge land bank worth 1,200 crore to Mr. Rakesh Hiramal, brother-in-law of Mr. Tadani, for a meager sum of 300 crores. See, before even understanding the provisions, when we apply our common sense and legal sense into the context, we easily know what is going to happen, right? So a property which is worth 1,200 crore is transferred to a certain person at 300 crore. For what reason? The reason is simple. If the CIRP begins, this property will move from corporate debtors' grasp, will be sold and distributed to the creditors. So this property now has to be safeguarded by the promoters for their own personal interest. How would they do that? They will simply transfer the property to one of their relatives. Later on, they all can enjoy the benefits of the property. But how? The guy cannot pay the market value of the property. Therefore, what we do is we give a phenomenal discount and transfer the property at a substantially lower rate to a relative. And later on, we can sell this in the open market at a market value and enjoy the benefits ourselves. So if you see, 1,200 crore is the market value, sale price is 300 crore. We saved about 900 crores, which we all can enjoy later. This is what I call as criminal intelligence, to which the lawyers and advocates must get accustomed to. We must start thinking exactly like what the CD promoters, creditors will think at a certain point, what kind of mischief they would play to protect their interests, and how we should circumvent the scenario and bring the real justice to all the parties involved. So you see that they've made an undervalued transaction for the benefit of the CD and its promoters. Now what happens? Let's say now at this stage, the CD goes into CIRP in the next 6 months. The RP, the first thing that it will do is, identify this transaction and say that this is an avoidable transaction. RP then files an application to NCLT and seeks a avoidance of this transaction. And if NCLT finds substantial evidence, it may call this as a undervalued transaction and actually cancel the transaction and make benefit to the CD. Now there's a practical case law that had actually happened, which was undervalued transaction, and how did NCLT decide on the matter. This case was by the directors of Adriatic Seafoods Private Limited. Remember, Adriatic Seafoods is not the corporate debtor. The directors of this company are suing Suresh Kumar Jain, who's an RP of a certain corporate debtor. Why? We will see that in the facts of the case. This is touching the legal provisions of section 45 and 46 of the Act, and the adjudicating authority is none but NCLT, which is an appellate tribunal. The principal bench dealt with this case, and the facts of the case are very simple as following. CIRP was admitted against Messrs. MK Overseas Private Limited. Now please mark, MK Overseas Private Limited is a corporate debtor which had done certain actions, and hence Suresh Kumar, the RP, will approach NCLT to actually set aside certain transactions under the head avoidance transactions, correct? So as far as who is a CD? CD is MK Overseas, not Adriatic Seafoods. Okay, now second fact, MK Overseas had several assets, which is a CD, and one of the assets was a plant situated at Panvel, Maharashtra in an industrial area. The plant and the property was mortgaged to Yes Bank. The company wanted to sell the property and distribute the proceeds. It sought NOC from the bank. That means now I am not able to repay the loans. Hence, the only option that I have in my hand is sell certain properties and keep repaying the loans. So it went to the bank, which is actually lender, and under whose charge the asset is situated. Without the NOC of the lender, you cannot actually sell the assets. So therefore they asked Yes Bank for permission, can I sell the asset? Yes Bank said fine, please go ahead. But the minimum sale consideration for transfer of such asset shall be 17.86 crores. Please look at the line, point number 5 in the fact, it is very clearly highlighted. So now what happened after this discussion with the Yes Bank? The property was actually sold for 63 lakhs, right? Where is 17.86 crores and where is 63 lakhs? I'll tell you why it was sold for 63 lakhs also eventually in the case law. Then point number 7 says the RP made an application for avoidance of this undervalued transaction to the NCLT New Delhi. NCLT ruled in favor of RP. That's why remember, this is a case with the NCLAT. That means it's an appeal. When RP has already got an order in his favor, he will not make an appeal. Hence, the other party against whom the order is obtained, it is making an appeal in court of law. Remember, corporate debtor sold the asset to Adriatic Seafoods Private Limited, and that buyer being affected by the order of the NCLT made an appeal to NCLAT and asked for an appropriate relief against the liquidator or the resolution professional Suresh Kumar Jain. Point number 8, NCLT ruled in favor of RP. Now point 9, now an appeal is preferred with the appellate tribunal by the buyer against the order of the adjudicating authority. Let's look at two sides arguments. What is appellant's argument? That is the buyer of the property for an undervalued consideration. The property was bought by way of a registered sale deed. There are several prayers made to NCLT which are pending. NCLT never heard us. The adjudicating authority passed the impugned order in a hurry without even hearing us. So, as an appellant, my argument to NCLAT is that NCLT, the adjudicating authority, violated the basic principles of natural justice by not hearing me and passing an impugned order against me. Hence, this appeal is justified in my view. Now, obviously, the respondent, what is he going to say? Respondent's arguments are very simple. The property's possession was given to the buyer in August 2019, just 2 months before the commencement of the CIRP, which started in 2019 October. And the value of the property, according to Yes Bank itself, is about 17.86 crores, whereas the actual consideration received is only 63 lakhs, and hence the RP feels that this transfer was in anticipation of a CIRP and hence should be avoided as an undervalued transaction. You remember, for an undervalued transaction, we said there are two things. Whether the transaction is with a related party. If it's a related party, I can go back 2 years. If it's not a related party, I can go back 1 year. In this case, the transaction is just within 2 months before the commencement of the CIRP, and hence there is a very good likelihood of it being called as a undervalued transaction. So what did NCLT say in conclusion? The NCLT said that the agreed consideration of rupees 11 crores was to be paid by the Adriatic Seafood to the CD, whereas actually it paid only 63 lakhs. So instead of recovering the balance consideration of about 10 crores odd, the CD actually gave the whole possession to the buyer for a meager consideration of 63 lakhs. This very clearly displays the intention of the seller, corporate debtor, that he wants this asset to be moved out of the company, not to be in the reach of the liquidation or CARP estate. Hence, the NCLT dismissed the appeal made by the buyer, citing that there are no merits in the case, and therefore, in this case, the RP has won in establishing that this is a undervalued transaction. So, quickly wrapping up what we have discussed till now, we have discussed section 45, 46, 47, and 48. 48 talks about how do you understand an undervalued transaction. 46 provides for relevant period, 2 years for a related party, 1 year for a non-related party. And what are the avoidable transactions? Gift on one side, transfer of property for a much less consideration than what is paid by the corporate debtor can be called as undervalued transactions. Then under section 47, we read that in case the RP or liquidator is not informing the adjudicatory authority, then the creditor himself can make an application under 47 and seek an appropriate relief. And in all the above cases, an order will be passed by the NCLT under section 48 of the Act. And along with that, we have seen a case law where a company has bought the asset at a meager amount of 63 lakhs against an estimated value of 17.68 crores. So friends, these are the kinds of mischiefs paid by the corporate debtors at the right time, and hence as resolution professionals, liquidators, they have to exercise their precaution in taking it forward, and therefore they have to bring these matters to the sight of adjudicatory authorities for appropriate relief. This brings us to the end of session 46, and we'll see you in session 47. Thank you.